5-05080 Vibe Credit Union versus Teresa Davis Seals.
All right, appearances for the record, please.
Good morning, Your Honor. Elizabeth Butler, P80956 for Plaintiff, Vibe Credit Union.
All right, good morning, Ms. Butler. And ma'am, what is your name?
My name is Teresa Davis Seals.
Okay, and good morning to you as well. Today is the date scheduled for 2 hearings, I see. We have a motion for summary disposition that was filed by the plaintiff, and then I'm looking at a letter which indicates that Ms. Davis Seals is requesting a motion to dismiss the case. So we'll figure out which one we would like to address first, but I'm thinking let's go with the defendant's motion first. Ms. Davis Seals, what's your argument?
Okay, Your Honor, I would like to say that Ms. Butler has no case, and the information that she has compiled in her packet that she does have, it's basically has come from me, from the mediation that we had of my receipts. She has no information, and she's now wanting this hearing to further get additional information from me to work against me, which is ridiculous. And I only came to this hearing today just to find out more about Ms. Butler and her affiliation with this credit union, why she's even with them, why is she working for this particular situation. I have no dealings with her and her organization or her company, and I see no reason to even be.
Welcome back, everyone. Today's courtroom drama has everything: confusion, misplaced evidence, and a Karen who believes that simply feeling wronged equals legal proof. This case pits Teresa Davis, who we'll call the reluctant litigant, against Vibe Credit Union. But here's the twist. Teresa claims she has proof that she's being scammed, except she forgot to bring it. Yep, you heard that right. She walked into court without the very evidence she says will clear her name. What follows is a masterclass in patience from the judge, disbelief from the attorney, and a slow-motion legal train wreck you can't look away from.
Now, you've asked me to dismiss the case, and in order to do that, we would have to have a legal basis to do that. And I hear that you're not happy with the fact that she's filed the case. You don't understand who she is. You don't like the fact that she's got information from you that she's using in the case, which, by the way, that's okay. Either side can use information from the other side. As a matter of fact, that's the process that we call discovery. And it is authorized under the Michigan court rules that you can ask each other specific questions about your side of the case or their side of the case, whichever you want. Any factual information, questions can be asked. You can ask for documents. Documents can be provided both ways, from the plaintiff to the defense, if the defense wants to see documents that the plaintiff has, and vice versa. So that part is technically okay. But for you to ask me to dismiss the case, I just can't dismiss the case. I have to have a legal grounds to do that. And I'm not really hearing specific legal grounds, although I am hearing some other things that you're not happy about. So,
Your Honor, can I say something else? I just want to bring out all the rest of my feelings and information and everything concerning this case on September the 25th for the trial. As I stated before, the reason I don't want to keep giving information pertaining to Ms. Butler here is because she has no information and she's trying to use me to build the case.
ma'am, that's okay. That happens.
You could be talking to them, not me.
Well, let me say this. If this case gets to trial, it is their burden to prove the case, but they can do that by any type of information, whether they got it from you, whether they got it from their client, the credit union, whether they got it from answers that were filed to interrogatories or your response to the complaint. That's okay. That's the way a lawsuit progresses. So it's not like she's doing anything wrong, but if she is using information that she obtained from you.
But, well, Your Honor, she's not giving me any. When this
Did you ask for any information?
Yes, but
Okay.
she didn't even answer her phone when I.
Let's pause right there. Did she just admit that she intentionally left her evidence at home? In any courtroom, evidence isn't optional. It's the backbone of your entire argument. This is like showing up to a job interview and telling the boss you left your resume on the fridge. The judge's face says it all. Disbelief mixed with judicial exhaustion. What's fascinating here is that Teresa thinks withholding evidence gives her some tactical advantage, when in reality, it only weakens her credibility. If you claim something is inaccurate, but you can't show the proof, the court can only go by what's presented. And right now, she's presenting a whole lot of nothing.
See if you went. I don't know.
Yes, Your Honor, we did go to
mediation.
Okay. So usually after mediation, can somebody tell me the date you went? Because usually that's when we would do a scheduling order.
I think it was August 14.
Okay. So I don't see a scheduling order back yet. This motion got filed though in August.
Your Honor, may I respond to the defendant's motion, or do you even need me to file?
Yeah, well, I'm gonna let you say what you need to say. I just wanted to make sure she was clear on the fact that some of the things she's complaining about are okay. So go ahead and respond, Ms. Butler.
Thank you, Your Honor. I mean, you said that there needs to be a legal basis for a motion to dismiss, and thank you for explaining that my client's entitled to ask for information from her. We attended the mediation, and I had asked her for copies of checks. I wanted to make sure my client had the right balance, that she was giving credit for all of her payments. She kindly provided that, and my client reviewed, and we filed our motion for summary disposition based on the balance, and we included a full accounting with the motion. That's what she had wanted to see, and she was served with a copy of the motion. I'm happy to.
Let me interrupt you a minute. I'm looking on my electronic filing, and I see the motion itself, but I don't see. Let me see if there's a brief. I was looking for the brief and I couldn't find it.
We filed a brief with exhibits and a proof of service and a notice.
Okay, let's see. I do see something that says exhibits, so let me see if that's it. Yes, you're right. Says exhibits, but there's the motion. Okay, there's that. Well, no, here's the exhibits. Okay, let's see if I got a brief with it. Okay, I've got all of the exhibits that you've attached right here. And it just says exhibits, but there's no motion. Let's see, notice of hearing there's no brief. I've got the motion, which is just your standard motion, but I don't have the argument. Do you know what date that you filed the brief?
On August 18th, the same day we filed the motion and those exhibits.
Okay.
Have
So
the
let me
file
look at
stamped
everything,
copy.
let me look at everything from August 18th. So here's the motion.
Here's what the judge is carefully explaining. Disliking the process is not a legal argument. Motions to dismiss must be based on law, like lack of jurisdiction, improper service, or failure to state a claim. Teresa, however, seems to think the court should dismiss the case because she's uncomfortable with it. The judge gives her credit for passion, but passion doesn't replace precedent. This is a great example of how judges maintain professionalism even when litigants blur the line between emotion and evidence. Watch closely here. The judge is doing more teaching than judging.
On August the 18th, that's also just one page. Then on the 18th, here is a proposed order. That's one page. Then the next document. Aha! There it is. I must have missed it before. Here's the brief.
No problem, Your Honor.
Okay. All right, go ahead with that, your argument then. You've got your documents attached. I see those.
Yes, Your Honor, this relates to a loan that Ms. Davis Seals took out with my client, the credit union. She seems to be under a misunderstanding that my office owns the debt. We're just the lawyers, provide credit union. They still own the debt. We're not a separate debt buyer in any way. We're just humble attorneys.
Yeah, you're just representing the credit union.
Correct, correct.
Mm-hmm.
Ms. Davis Seals had a loan before this loan that's the basis of the lawsuit. The loan that's the basis of this lawsuit was a debt consolidation loan, where she was given a new loan. So Ms. Davis Seals had made payments on that prior loan, and my understanding is that she's concerned she didn't get credit for those prior payments. I think what she's not understanding is that this was a new loan, and the payments made before don't apply to the new loan. The new loan encompassed all her prior payments and what she'd owed before. After mediation, she kindly provided my office with copies of her receipts. I had my client double check everything to make sure that all her payments were credited. She had admitted that she missed some payments, which is the basis of the default on the loan. Attached to the motion for summary is a full accounting of all her payments and also an affidavit of account from my client confirming the balance. That was the basis for the motion for summary. She doesn't seem to be contesting that she took out the loan, that she owes money. She just was worried about the payments, thus the full accounting affidavit of the balance. I'll also point out she hasn't.
And here we go. This is courtroom comedy gold. Teresa complains that the opposing attorney didn't answer her phone call, as if that's the same as a formal discovery request. But discovery in civil law has rules. It's written, filed, and part of the court record. Missed calls and voicemail don't count as evidence requests. You can almost feel the judge fighting back a sigh. This moment perfectly shows how misunderstanding procedure can make someone look unprepared, even if their intentions are good. The takeaway? In court, formality isn't bureaucracy. It's protection.
Okay, so Ms. Davis Seals, I'm going to give you a chance to respond, but the gist of her argument is that, number one, she's just the lawyer for the credit union. She's not trying to collect the debt for any other entity other than the credit union. And that's how she's involved in the case. Number two, she indicated that at the mediation, she got your documents to make sure that you were credited for any payments that you had previously stated that you made, and that there was a prior loan, and then you got this new loan for debt consolidation. And they verified that all of your prior payments were indeed credited to the other loan. And this is a new loan. And that you've admitted that you pretty much owe this loan. There's no question there that you owe that debt. You had missed a couple payments, so that's the default. And otherwise, she says she's checked her balances, and this is the correct amount that's due, so that there really is no issue to go to trial on. And if there's no issue to go to trial on, we could enter judgment for the credit union today, because there's no issue. A trial is held when there are actual issues that we're not sure, well, what's the facts? This
Okay,
case, she argues, these are the facts. No one's disputing the facts.
I'm Your Honor, let me speak on each one of those issues you just mentioned. Number one, this is a debt collection agency that's working for them. They have bought out this account from this credit
Ma'am, there's
union.
no evidence of that.
That they have. The paperwork that let me finish talking. Your
I
Honor.
need you to, I have to be based in reality here. So I need you to show me what documents you have that support the fact that they bought the debt and that they're actually the people collecting it, because the lawsuit is not in the name of the law firm. And it's okay for a debt collection law firm.
This is where we see judicial diligence in action. Notice how the judge isn't just taking anyone's word for it. She's combing through filings, checking timestamps, verifying exhibits. Judges often do this behind the scenes. But here, we see it in real time. It's a subtle reminder that in court, paperwork is power. The side with better documentation usually controls the narrative. Meanwhile, Teresa, who left her paperwork at home, is watching her case crumble under the weight of organization. Attorney Butler delivers this beautifully, calm, professional, and airtight. She acknowledges Teresa's confusion about who owns the debt, and then carefully dismantles her arguments one by one. This is what you call legal precision. Notice how she doesn't attack Teresa personally. She simply walks the court through facts, documents, and procedure. And that last line, about no genuine issues of material fact, that's the legal knockout punch. Translation, there's no actual dispute left for a trial. The facts are one-sided, and Teresa's missing evidence won't save her now.
I have paid over $8,000 and plus dollars for that whole loan. It became a consolidated one loan. And they are not accurately giving me the credit for the amount that I have paid.
Okay, ma'am. Well, you're going to have some documentation to show
I have
me.
it. It's at home. Like I said, I didn't bring anything.
Today was the date to bring it. We don't get to trial when there's a motion pending. And in order to actually respond to the motion, you needed to have brought your information today.
It was my understanding this was just a hearing before the trial.
It is a hearing before the trial, and it could end up that you don't get to trial if her position is substantiated.
Well, it's not accurate. They have false information regarding what I have paid, and everything else that she's saying about this, what they have done is false and against what is actually true.
Okay,
and
ma'am.
I wanted to bring out all of my information
You don't have
during
it.
the trial. That's what I thought I could do.
We don't get there. This is the date to do that. This is a motion for summary disposition. That means this is the date where the case could be totally dismissed, and we don't get to trial based upon their motion. This was the date for you to file a response, like she said, which you did not do, but that's okay. If you had brought some information today, we could have dealt with it orally to some degree. But if you don't have anything, I can't just go on your word that they did something false.
I have it at
Gotta
home.
have document. Ma'am, you were supposed to, I don't know why you would come to a court hearing without the
Because
proper.
I thought this was just a hearing, that we were just supposed to voice. It was I thought it was similar to that orientation we had, which, by the way, she started with one.
And here comes the boiling point. Teresa's frustration is about to explode. She's doubling down, accusing the lawyer of being part of a shadowy debt-buying scheme. Even though there's no evidence for that claim, what we're witnessing isn't just confusion, it's cognitive dissonance. When someone believes they've been wrong but the facts don't support it, they start creating explanations to preserve that belief. It's human, it's emotional, and it's tragic. The judge stays remarkably composed, reminding her, again, that belief isn't proof. At this point, the outcome is all but sealed.
Of how much I have paid, but not giving me credit for it. I do not owe the amount that they're saying, and I should not be assessed anything any different. This is a collection agency that has gotten that account. They want to take it over and want me to start from a whole big balance amount of which is not true. I have paid this credit union over $8,000, $8,231.07. And they are not giving me the credit for it. And then they want to continue on with a huge balance. How can you come with a balance of 11,000 plus when both of the borrowed amounts were 7,000 each, and I have paid over $8,000 plus?
Ma'am, I don't know. You have to look at-
3,500 left.
You have to look at the terms of your loan agreement. I'm sure there's interest and penalties on late payments that apply.
And I'm glad you mentioned that, Judge. And what she said earlier about missing some payments, I've never missed. I've been late, and I admit that. But the late ones I have gone up with and moved forward. There's no way I could reach $8,000 plus not paying. I have paid late. I've never missed. So that's an incorrect statement that she has made. This credit union is crooked and biased and is sorry for that she's representing them on the
End of today's courtroom drama. Teresa's case is a perfect example of how emotion can overpower logic when you step into a courtroom unprepared. The judge remained fair and patient. The attorney stayed grounded in evidence and the law. Once again, favor documentation over declaration. Whether you're representing yourself or just fascinated by courtroom strategy, remember this: facts win cases, not feelings.